the people that represents what we try to do in this association, which is to think about the law and legal rights and to think about how that affects the patients that we care for and how we deliver services to them. We're constantly balancing. It's actually more like juggling for us a lot of days, and sometimes it doesn't feel like we're juggling very well. And Michael's going to give us a talk about some new areas that he's been doing work in, and it's perfect timing for us. We're really glad that he could be here to present things to us. A special little thing for Michael, this is, you have to be kind of nerdy to get this reference, but in some respects, like I said, what we deal with is about freedom. We're trying to help people be free, try to help them be free within the law, to help them live lives free from violence, to help them live lives free from disability, from mental disability. And in a sense, we could be striking for the gentle, striking for the kind, striking for the guardians and protectors of the mind. One of our greatest poets, Bob Dylan, personal favorite of Michael Perlin's. So chiming for freedom today, Michael Perlin.
Thank you so much, Steve, for that very kind introduction. And what I don't think you know is I use that exact lyric for another article. I've written, and there's a quasi-relationship, an article about guardianship laws around the world and how the use of these laws actually imprison people, very often in forensic facilities, and how the Convention on the Rights of Persons with Disabilities, which is one of the focuses of what I'm going to be speaking about, can be used as a tool to remediate that. So that was really absolutely perfect. Thank you so much. And it is a real pleasure to be here. I was thinking, what was the first year, Steve, that this, 2000 Vancouver? Right, I keynoted that. And this is my first keynote since, every 13, 14 years. It's pretty good. And I've been to several conferences, of course, in the interim years, but it is really a pleasure to be here and to see so many old friends and colleagues, and also to see some new faces, which for me is always a very, very good thing. I don't think that it is any secret to anybody in this room that historically, persons who are have been institutionalized in psychiatric institutions and in facilities for people with intellectual disabilities have always been hidden from view. And you see the beginning of my title, and I'll get back to that at the end, is "You That Hide Behind Walls." Facilities were often constructed far from major urban centers, availability of transportation was minimal, and those who were locked up were seen to the public as faceless and perhaps less than human. There were some sporadic exposés in the 19th century and the early 20th century, but it was not until the Civil Rights Revolution reached psychiatric hospitals and facilities for persons with intellectual disabilities in the early 1970s that there was any true public awareness of the condition in such facilities. And I should say, I've been a professor for many years, but I was a real lawyer for 13 years before that. I was a public defender in Trenton, New Jersey. I was director of the New Jersey State Division of Mental Health Advocacy, and I cut my bones representing persons at the Vroom building, which was then the maximum security facility for the, quote, criminally insane in New Jersey. And it was a case that I did there that really kind of catapulted my career. This was in the 1974, 1975. I used to tell people I was 11 years old at the time, but people have stopped laughing, so I'm not going to do that anymore. And it turned out there were people who had been institutionalized from 1958, 48, 38, and 28 without a hearing, that had been locked up in cells allegedly awaiting trial. So that's kind of what got me started in all of this. And it's no secret that a series of cases brought around the United States by young civil rights lawyers in the early 1970s really changed the entire landscape in terms of how the laws that governed treatment of people in psychiatric hospitals. Other cases followed soon after in Western Europe. All this led to the predictable empowerment of blue ribbon commissions, the issuance of lengthy reports excoriating states for shameful conditions, the tardy passage of Patients' Bill of Rights, and on and on. And perhaps as a byproduct of this, those individuals who had been hidden, whose voices had been silenced, began to raise their voices to protest the dehumanization of the conditions in which they had been confined. Importantly, much of this case law ignored forensic patients entirely. By and large, although not exclusively, the facilities that were the subject of this litigation and the concomitant press scrutiny were facilities that mostly housed persons who had never been charged with or tried on or charged with a criminal case. And that fact is discordant, of course, with the, quote, ordinary common sense that posits that most mentally ill individuals are dangerous and frightening and are more dangerous than others. But even in this hidden world of persons institutionalized because of psychiatric disability or alleged disability, forensic patients, mostly, at least in the US, those awaiting incompetency to stand trial determinations, those found permanently incompetent to stand trial, those who had been acquitted by reason of insanity, in some jurisdictions, individuals transferred from correctional facilities, this population has always remained the most hidden. And this extra set of level of social isolation was just fine with most of those who had been involved in the patients' rights revolution that restructured mental health care around the world. It was fine to the advocacy groups that came forward at the time, since the existence of a forensic world could be used as evidence that there appeared to be some kind of relationship, in some cases at least, between mental illness and dangerousness. It was fine to the lawyers who brought the first generation of public interest cases, since one of the significant underpinnings of the initial right to liberty, least restrictive alternative civil rights suits was that patient was never alleged to have committed a crime. It was fine to the state hospital systems, since it was clear that if this population were to be released or deinstitutionalized, there would be a public outcry. And it was fine to prosecutors and police officials, since it ensured to them that this population would be locked up indefinitely. As a result, things remained basically status quo for about 40 years. And in many jurisdictions around the world, and I should say, I have traveled the world in the last 15 years doing advocacy work, doing site visits, speaking internationally, teaching internationally. I have spent lots and lots and lots of time in Central and Eastern Europe, in Central and South America, and Asia. So I've got a little bit of street cred on this issue in terms of the number of nations in which I've actually seen these facilities. And very, very little has changed. I would not use the Dylan song, "Things Have Changed," for this title, because they have not. But, and here's the but, and this is really kind of the heart of what I'm going to be talking about. This state of affairs must be radically reconsidered in light of the ratification of the United Nations Convention on the Rights of Persons with Disabilities, the CRPD, which is regarded as finally empowering the world's largest minority to claim their rights on an equal basis with others. This convention is the most revolutionary international human rights document ever. It furthers the human rights approach to disability. It endorses a social model of disability. It reconceptualizes mental health rights as disability rights. It clearly repudiates the medical model that traditionally was the core of mental disability law. And there is no question it has ushered in a new era of disability rights policy. I should note Canada has ratified the convention. The US shamefully still has not. It has been signed by President Obama, but a recent utterly obscure case, except to those people who are even as nerdy as I in terms of reading everything the Supreme Court does, a case called Bond versus US, having nothing to do with anything that we deal with here, I believe is going to be the open sesame that's going to unlock those 4 or 5 missing votes. So I expect the next time the Senate takes it up, it will pass. I can talk about that later on if anybody is interested. My over-under for how many pages I can get through before my first water is 3. I made it to 5. It's not bad. The convention calls for, I'm just quoting several of the articles, respect for inherent dignity, for non-discrimination, freedom from arbitrary or unlawful interference with privacy, freedom from torture or cruel, inhuman, or degrading treatment, freedom from exploitation, violence, and abuse, a right to protection of the integrity of the person. The CRPD is unique because it is the first legally binding instrument devoted to protecting the rights of people with disabilities. And it not only clarifies that states should not discriminate, it also sets out explicitly steps that states have to take to create an enabling environment for authentic equality. There's two kinds of rights in the law. I'm going to go into law professor mode for 12 seconds. Proscriptive rights and prescriptive rights. Proscriptive rights are thou shalt not. It's the shield right. Prescriptive rights are thou must. It's the sword right. And the CRPD has both. You must not do X and you must do Y. And I think that's very, very important. One of the most critical issues in seeking to bring life to human rights law in mental disability law is the presence of counsel. Those of you who have heard me speak before know I always speak about this. I am incredibly counsel-centric when it comes to these issues because I know, again, taking the long view, because I've been doing this work for 40 years, meaningful reform in prisons, meaningful reform in hospitals, meaningful reform in state schools for people with intellectual disabilities in the United States only came about in those states where there was vigorous advocacy, dedicated counsel. I mean, the correlation is nearly perfect. And the CRPD mandates state parties to provide access to people with disabilities to the support they require in exercising their legal capacity. State parties shall ensure effective access to justice to persons with disabilities on an equal basis with others, including at investigative and other preliminary stages of hearings. So this is not solely a warm body next to you at a hearing. This is to develop a case, and that's incredibly, incredibly important. Now, the ratification of this convention must be read hand in glove with another document, the United Nations Convention Against Torture. Together, these documents will make it likely, or should make it more likely, that for the first time, attention will be paid to the conditions of confinement worldwide of this population, how these conditions regularly violate international human rights law, and how those who run such institutions in many portions of the world do it with impunity. In 1985, Canada ratified this convention. In 1988, the US ratified it. Congress even passed domestic legislation to make it enforceable under domestic law. The purpose of this convention was to establish a comprehensive scheme with the aim ultimately to end torture around the world. What's torture? Severe pain or suffering, whether physical or mental, intentionally inflicted on a person. And it goes on and on from there. Just recently, scholars are beginning to look at the relationship between the Torture Convention, CAT, and the Disability Rights Convention, CRPD. And people are now starting to write. A great article in the University of Miami Law Review a couple years ago by a woman named Catherine DeMarco about how the Convention Against Torture has to be read with the CRPD when looking at supermax prison conditions in the United States. Janet Lord, another scholar, has talked about the relationship between the CRPD and the torture prohibition, how they have to be read hand in glove together. So this is something that I'm saying we in this room doing the work we do need to start thinking about. But there has been very little follow-up on these initial ideas, and that gap is problematic. If we are ever fully and effectively contextualize these two conventions in the context of the treatment of persons with disabilities, especially those institutionalized because of mental disabilities, we need to do that. So today I'm going to focus on the relationship as it deals with the treatment of institutionalized forensic patients, highlight some of the key issues we have to think about, examine these issues through the lens of therapeutic jurisprudence, which is something I've been thinking about, writing about, talking about, and advocating about for nearly a quarter of a century. And I will conclude with some recommendations and an explanation of the lyric that begins the paper. So as part of this enterprise, I've identified 6 core issues that must be on the table if the scope of the underlying problem is to be understood. At this point, my students would say, 6 issues. This is probably going to be in the final. Better start taking some notes, right? 1, although there is a robust literature on the CAT and the CRPD, there is virtually no mention in either on the conditions of forensic patients. So even within the world of those who focus broadly on these human rights issues, this population has remained invisible. 2, conditions at forensic facilities around the world continue to shock the conscience, and we have to deal with that. And I say that as somebody who has been in these facilities in Hungary and Bulgaria, in Uruguay and Nicaragua, a little bit in Uganda, and some other places. 3, even when regional courts and commissions have found international human rights violations in cases involving forensic patients, and I'll be telling you later about an Ecuador case called Victor Rosario Congo versus Ecuador, the discussion of these cases, even though they're about forensic patients, the discussion in these cases largely ignores the plaintiff's statuses as forensic patients. 4, there are few lawyers and even fewer, quote, mental disability advocates providing legal and advocacy services to this population. 5, there is little mention in the survivor movement literature. Those are people, groups of people who refer to themselves as psychiatric survivors, people who have been institutionalized and are no longer. Very robust in the US, and I expect in Canada as well. There is virtually no mention of forensic patients in the literature I've seen. And number 6, forensic patients in facilities for persons with intellectual disabilities are particularly absent from this discourse. So those are my 6 main issues. Number 1, ignore. How are these patients ignored? For years, scholars have written extensively about the Convention Against Torture. For the past 6 years since ratification, robustly about the CRPD. But there has been shockingly little written about the applications of either convention to forensic patients. And I'm kind of chagrined to say, when I went to Westlaw and to Lexis to study the literature, the only articles I could find were ones that I wrote. So that's not a good thing. About 6 years ago, in another talk, I listed what I saw as the 5 core issues. I like core issues, it's a cool thing, of the overlap between mental disability law and international human rights law in general. And one of those factors was failure to provide humane services to forensic patients. And in that article, I said this: virtually all studies and reports referred to in this article have focused on the status and plight of civil patients, those whose commitments to the mental health system were not occasioned by arrest or other involvement in the criminal court process. Depressingly, persons in the forensic system generally receive, if this even seems possible, less humane services. As I said, I wrote that, I think, 2007, 08. I did a check. This article's been cited a lot. That's been very nice. But there is not a single reference anywhere in the literature to this point. In other words, even in an article that's gotten a lot of attention in a lot of different guises, no one has ever picked up on this argument that forensic patients have it worse worldwide. And I think that's like Sherlock Holmes, the dog that didn't bark in the night, I think is of some significance. I think this lack of academic interest raises serious questions as to the extent to which ongoing and serious violations of both conventions will ever adequately come to light. So that's number 1. Number 2, what about conditions? If you read studies about forensic facilities, and these come from a whole variety of sources, from the kinds of white papers that inevitably gather dust on shelves, sometimes they're on websites, they're very, very rarely in the journals that we regularly read and edit, but they tell with deadeningly similarity stories of mistreatment, lack of treatment, wholesale violations of civil and constitutional rights abuse. It is as if the CAT and the CRPD were not intended to apply to this population. More stunningly, there is virtually no mention in the legal or psychological literature of this turn of events. Historically, psychiatric facilities around the world have been beset with conditions so deplorable and inhumane, their existences have been a shock to the conscience. Revelations of residents subjected to excessive electroshock therapy, prolonged isolation, hours of being shackled to the walls sparked advocates back in the 1970s, I'm talking, to begin a slow journey towards change and equality. Ratification of these two conventions should have led to an amelioration of conditions, but in many nations this has not happened. I was sitting in a room in Sofia, Bulgaria 12 years ago where electroshock therapy is used in an unmodified format. In other words, patients are not given muscle relaxants before that, something condemned by every body, that's not any person, every governing body, any standards body that's ever looked at it. And this guy from the Bulgarian Psychiatric Association said, Mr. Perlin, I don't care what you say, I don't care what the United Nations says, I don't care what the World Psychiatric Association says, I'm going to continue to do what I've always done and you can't stop me. He was right. I couldn't stop. I'm going to beat him up, bore him to death with my stories about old baseball scores from the 1950s. He was right. I could not stop him. But there was no one there who had the ability or the authority or the will at that point to stop him, because at that point there was no convention on the rights of persons with disabilities. In many nations in the world, forensic patients suffer in unlivable conditions that offer no hope for rehabilitation and little optimism for the future. And this is all ignored again by advocates and by policymakers. Now it's interesting, there is no mention in the CRPD of forensic facilities or forensic populations. Why? What needs to change so that the rights of all human beings, including that very population that every single one of the 396 of the people in this room have devoted their lives to, what needs to change to make people around the world subject no longer to these less than human conditions? Well, again, those of you who have read my work and have heard me speak know I always talk about heuristics, cognitive simplifying devices. Heuristics come to play with a vengeance when they're linked with the criminal justice system. Again, while statistics make it clear the majority of individuals with mental disabilities and disorders are not more prone to violence than others, the public at large disregards that and takes one case that's going to be on Action News tonight or somewhere at 11 o'clock and blows that completely out of this world. I'm just back from a week in Taiwan. I was giving lectures to law schools, to medical schools, to judges, to civic groups. 2 weeks before was a horrible case. Some guy who, by the way, had no mental health history, stabbed and killed 4 people on the Taiwanese commuter rail train. I did not give a single talk in which that was not the first question. I mean, this was just, and these are rooms full of not, lay people and judges and law professors and medical school professors. That still was the first question, that vivid heuristic of the horrible case. That's there. We have to deal with it. Of course, this gets distorted by the media. Of course, this leads to a subculture of fear and misunderstanding. And this is not only an issue that I have dealt with over the years in the US, it's an international issue. And I'm not going to read, because it gets tendentious to read all this, but in this, as I may have said at the beginning, today's paper comes from a book chapter that's been published very, very recently, and it's available actually for free online, in a book called Torture and Ill Treatment in Healthcare Settings by the American University Center on Humanitarian Law. So you can get the full Monty there with 178 footnotes if you want. I am not reading you my 178 footnotes because I want to be able to get out, at the border tonight. But in this, I talk extensively about conditions studied at forensic wards in Argentina, where 75% of the forensic patients had no access to a toilet. Wrap your arms around that for a while. To facilities in Hungary, where instead of hiring guards for forensic facilities, the Hungarian mental health department thought it'd be a cool idea to take prisoners from Hungarian prisoners and have them watch over the forensic patients. In Albania, where any forensic patient doesn't go to a forensic facility, but rather goes to prison before he is tried. And even though anyone in the psychiatric system is supposed to have a hearing every year to determine whether he's supposed to still be there, in Albania, 5 years is kind of the minimum. I could go on and on. There's examples in the UK, there's examples in the US. But again, we use the phrase shock the conscience as kind of a legal trope. Certainly some of the things that I have seen in some places did exactly that. They violate the decencies of civilized conduct. And I think we have to deal with that. We have to accept that, and we have to work I'm sorry, to expand the reach of documents like the CRPD to include this marginalized and often forgotten population. And we have to think about the pretext, that's something else I talk about all the time, before us. To think about the amount of discrimination that this group of people face in the world from many perspectives, making them more susceptible to this kind of ill treatment, and there being fewer fans on the outside to care about it. Access to even the most minimal health care is a barrier. Lack of treatment, of course, can also lead persons with mental disabilities to be inappropriately and disproportionately arrested. I mean, there's so much literature on that in terms of what do police know, the different, and some cities have adopted, I think really terrific plans to minimize that. But it is certainly not constant. In some of the cities, and there's a Memphis plan, I guess, some of the cities that have done that have cut back on it because of alleged too much cost. So the other cost, of course, is putting people, in jails and prisons. I mean, there are so many sub-issues. How often people with mental illness are brought to jails instead of mental hospitals in the first place because time can be how much more time-consuming the mental hospital drop-offs are, and how policemen feel the mental health facilities are not really supportive to them. Lack of coordination, I've written about this in other articles, between mental health professionals and the police. And there's much more significance placed on the arrest itself than the acts or the clinical conditions of the apprehended individuals. Off point just a little bit, years ago when Giuliani was mayor in New York City, there was a crackdown on homeless persons, and I went in to teach mental health law the next day, and I had two students, a young woman who was working for a New York State Supreme Court, in New York that's the trial court justice, and a psychiatrist who was working at Bellevue. And it was very interesting as to which of these people, they were all homeless people, all around grates and subways, who was taken to the civil court and who was taken to the criminal court. Because Craig, the medical student, got the criminal patients, and Susie, the woman working for the judge, still got the civil patients. And it turned out that if the patient spoke, or the homeless person spoke back to the policeman saying, I don't want to go, I'm not going to be here, he was arrested for resisting arrest. He wound up at Bellevue, and he then wound up with a forensic sticker on him for the rest of his life. I've always said in New York City, the most important mental health decision maker on the micro level is the cop on the beat. The most important mental health decision maker on the macro level is the headline writer for the New York Post, our most garish tabloid. And I think there's a connection between that and everything I'm talking about when we think about who winds up in these facilities. So after the involvement in criminal justice system, I've also always talked about saneism, the kind of prejudice against persons with disabilities. It's doubly upsetting to people in forensic facilities who have not been convicted of a crime. And harken back to my case from the mid-1970s, these people, in fact, I wound up spending a lot of time on one case from a guy who was charged with a homicide in 1948 of which he was factually innocent, and a good public defender in his 3 days out of law school would have been able to be successful in that, but because he wound up at the mental hospital, never happened. Shedding light on the deplorable conditions worldwide in forensic facilities, spreading awareness about the treatment to which so many patients in so many parts of the world are subject is the first step in ensuring equality. I think once this population is seen as human beings, the stigma of mental illness may fade. In the late 70s, early 80s, I filed a suit again. A lot of my sentences start like that, right? I filed a suit against the Veterans Administration. I read the stories in the paper today, for those of you from the US, about the VA and the scandal. I said, there is nothing new under the sun at all. And I was suing basically on behalf of Vietnam veterans who were being treated back then much worse than World War II or Korean veterans. in the hospitals for all sorts of fascinating socio-political reasons. And I sued the VA to get the VA to create a patient's Bill of Rights for such patients, and I'm very happy that we were successful. But in the course of his opinion, this is one of the published opinions, a case called Falter, F-A-L-T-E-R versus VA. Judge Ackerman says, basically this case is about how plaintiffs are being treated as human beings. And of all the litigation I've done for 40 years, that's the one sentence that is stuck in my mind, that's emblazoned on my brain. And it's so easy to forget that from the perspective of the law. Okay, that's number 2. Number 3, regional courts and commissions. All right, second law professor lecture. In every part of the world except for Asia and the Pacific, there is a regional human rights court or commission to adjudicate violations of international human rights law. A very, very robust one in Europe, a getting more robust one in the Americas, a not quite so robust one in Africa. I mentioned to you earlier on a case out of Ecuador called Victor Rosario Congo versus Ecuador. A 48-year-old man who, as a result of the state's gross negligence and willful act, died of malnutrition, hydroelectrolytic imbalance, and heart and lung failure. He was beaten on the scalp with a club, deprived of medical treatment, and kept naked in isolation in a jail, in a forensic cell in Ecuador. And the Inter-American Court found that the state was responsible under the American Convention on Human Rights and what were called the mental illness principles, which was a forerunner of the CRPD. They found that keeping this person, a mentally ill man, in solitary constituted inhuman and degrading treatment in the convention, identical words to what's in the Convention Against Torture, identical words to what's in the CRPD, and that the state violated his right to be treated with respect and inherent dignity. Also, his right to judicial protection was lacking because there was no judicial avenues available to establish the cause of the injuries. And remarkably, the commission ordered his family be compensated, and that was done, which really stunned me. I mean, the fact that they actually paid, and that medical and psychiatric care be provided for other persons suffering from mental illness, and that individuals who had been arrested had to be assigned a specialist to determine if they had psychiatric disorders. Now, this is the Inter-American Commission on Human Rights speaking in 1999. That is certainly not the only case, but it's a highlight case to underscore what can happen, what does happen, because I can point to many other nations as well, and also, again, kind of, you know, my usual C major chord here, how bereft of legal advocacy Mr. Congo and anybody like Mr. Congo was. Leading to number 4, lack of lawyers. Well, with all this stuff coming out, you can question the role of lawyers and mental disability advocates who should be working to protect and ensure the rights of these individuals. But there are very, very few available in forensic populations around the world. There are numerous hurdles that any advocate representing a person in a hospital has to kind of get their case into court. The burnout rate is high, the jobs are underpaid, fewer and fewer people willing to do the work. Cuts in mental health budgets lead to cuts in the number of advocates. Very little training, very few American law schools even offer courses in mental disability law or correctional law. And lawyers shy away from cases like this. They also, if they do it, they may be overwhelmed by the tsunami of prisoners and forensic patients with serious mental health needs. I mean, no good deed goes unturned. You know, you do one case for somebody, and the next day there's 17 phone calls saying, can you also represent me? I understand that, but that's a reason a lot of people will not do this. And even when people are trained, there is still, among some people who call themselves advocate, a fear of this population, and that places both them and their clients at a true disadvantage, making effective representation almost impossible. So there is a pressing need for advocates in this area. It becomes more essential when we think about the fact that none of these conventions are self-enforcing. There has to be somebody willing to step up and say, yes, I will take representation of this person and provide them counsel in this area. Now, both the CAT and the CRPD try to remedy this. Article 10 and Article 4, Article 10 of the CAT, Article 4 of the CRPD both seek to promote education and training to professionals. So they are there in the conventions. But very, very little has happened. Article 8 of the CRPD talks about promoting awareness through society. I mean, there's some real important obligations here. The U.S. situation is particularly vexing because in many jurisdictions, statutory limitations prevent public defenders from representing those not currently subject to criminal prosecutions. So if somebody has been permanently Jacksonized and his indictment dismissed, the PD is barred from representing him. In many jurisdictions, there is no statewide public defender. This is always a shock to my students who come, if not from New York and New Jersey, basically come from blue states on the coast where there are robust public defender systems operating. In many jurisdictions, public defender systems are county by county. In some, they are city by city. And in others, they simply don't exist at all. Let's imagine I am the trial judge. There's a caseload of indigent defendants. Assume you guys are all lawyers. Say, okay, Mr. Hart, you're going to represent that guy. Mr. Doyle, you're representing her. Mr. Resch, him. Mr. Simpson, her. That's how representation is in many parts of the country. So this notion of the cohesive, unified public defender's office that I used to run in Trenton, New Jersey, and, from generation to generation, my son is a public defender in Brooklyn now, about which I am so proud, but I digress. The point is, in many jurisdictions, there are none. 1972, the Supreme Court in Jackson versus Indiana issues the decision that says you can't be kept indefinitely if you've been found unlikely to regain your competency in the foreseeable future. In 1985, Bruce Winnick studied this and found that Jackson had only been implemented in 23 of the 50 states. In 1993, Reed Malloy and Grant Morris restudied it and found it was up to 24. In 2000, I restudied it, it was up to 25. In 2012, Andrew Kaufman and a colleague restudied it, it was up to 26. Terrific. By my calculations, that means by the year 2176, every state will have implemented a United States Supreme Court decision from 1972. And this is really, really troubling. And again, one of the reasons is lack of counsel for this population. Number 5, there is very little mention in the survivor movement about the specific plight of forensic patients. So even in the world of those who focus broadly on human rights issues as they affect people with disabilities or perceived as having disabilities, this population is invisible. It may be that survivors feel forced into continued silence because of the additional stigma that perpetuates individuals with mental and intellectual disabilities in forensic settings. Talking about their experiences if they've been in forensic facilities might ostracize survivors in their community, causing supplemental discrimination. There may be a fear that bringing this to the forefront kind of solidifies the categories of us and them, demeaning the very purpose of the survivor movement. And survivors may also be hesitant to speak out because of the learned helplessness while in forensic institutions. There has been virtually no dialogue in the NGO community about this, and that's something else I want to call attention to today. Then finally, number 6, patients in facilities for persons with intellectual disabilities are particularly absent from this discourse. I don't think we can forget about this population any longer. Although finally we are recognizing that this is a very complex patient group whose needs are not well met, there has still been minimal attention paid on the high rates of abuse and neglect faced by this population. And I think that's something that we all need to talk about. Unlike mental illnesses that can for some be treated with a prescribed medication regime or alternative forms of therapy, intellectual disabilities are perceived as being permanent, making it even less likely that potentially ameliorative interventions would even be tried in forensic facilities. Without proper training and rehabilitation programs, holding such individuals under such circumstances in and of itself, getting no treatment at all, just simply being locked up 23 hours a day may be seen as a kind of torture. So those are my 6 main factors. Well, I told you I was going to talk to you about therapeutic jurisprudence a bit. Some of you may be familiar, some not. I will give it kind of the 45 RPM version, for those of you more or less of my generation. This has been going on for 25 years since David Wexler and Bruce Winnick, may he rest in peace, started talking about this. The notion is therapeutic jurisprudence is a model for assessing the impact of case law and legislation, saying that law as a therapeutic agent can have therapeutic or anti-therapeutic consequences. Its aim is to determine whether legal rules, procedures, and lawyer roles can or should be reshaped to enhance their therapeutic potential while not subordinating due process principles. I've written this elsewhere. An inquiry into therapeutic outcomes does not mean that therapeutic concerns trump civil rights and liberties. It asks us to look at the law as it actually impacts people's lives and focuses on the law's influence on emotional life and psychological well-being. I think that's a cite from Ian Freckleton, who's going to be your keynoter on Saturday. It's part of a whole comprehensive movement trying to establish more humane and psychologically optimal ways of looking at the law. It's an ethic of care. My friend and colleague Amy Ronner writes about this a lot, and she talks about therapeutic jurisprudence's commitment to dignity by focusing in on the 3 V's: voice, validation, and voluntariness. What they commend, she says, is pretty basic. Litigants must have a sense of voice or a chance to tell their story to a decision maker. If the litigant feels the tribunal is genuinely listened to, heard, and taken seriously, the litigant's story, the litigant feels a sense of validation. That, of course, links in with procedural justice. When litigants emerge from a legal proceeding with a sense of voice and validation, they are more at peace with the outcome. Voice and validation create a sense of voluntary participation. The question to be posed is this: to what extent can international human rights law reach out to therapeutic jurisprudence to best ensure that the principles articulated by Professor Ronner, the principles of voluntariness, voice, and validation, be fulfilled in matters involving residents of forensic institutions? There's been astonishingly little written about this relationship. There's been some important work done on the relationship of TJ to the application of international human rights law to prisoners and detainees with a mental illness, much of it a response to the reality that the conditions of prison and forensic facilities around the world are textbook examples of anti-therapeutic conditions. I've written a couple of articles with Astrid Bjergden, a forensic psychologist from Australia, whom you might know about this. Ivan Zinger, who is a Toronto guy, and is Ivan here? No, all right, has argued the best approach to ensure that the rule of law is upheld is to view corrections as being in the human rights business. The best argument for observing human rights standards, Zinger says, is not merely that they are required by law, but they work better than any known alternative for offenders, for correctional staff, and for society at large. But again, Zinger's focus and most of Astrid's focuses, were on prisons, not on forensic facilities. Conditions in forensic facilities around the world, again, shock the conscience, and in many cases are so bereft of humanity, they challenge the notion we are a civilized society. These conditions scream out for an in-depth TJ analysis to demonstrate their destructiveness and their negative impact on the mental health of those unlucky enough to be housed in some of the facilities I've described. I've written elsewhere that the CRPD is a document that resonates with TJ values. There has been recent interest in the overlap between TJ and the CRPD, but it has not, by and large, been extended to the specific problems faced by residents of forensic institutions. I hope this presentation may lead some others to consider these issues. Okay, I'm almost done. Forensic facilities and their populations, again, have traditionally been hidden from view. This has been scarce notice. Most of the people involved in the relevant systems seem passively comfortable with the status quo. But the state of affairs that we now face violates international human rights law and the precepts of therapeutic jurisprudence. We can no longer keep the state of affairs hidden behind walls. Speaking of which, my title. Again, no surprise to Steve and Ron and to Michelle and to Barry and to Dennis. The title of this paper draws in part on Bob Dylan's magisterial song, Masters of War. In this song, Dylan acerbically calls out those. He mentions war profiteers, munitions manufacturers, the lords of the military-industrial complex who hide behind walls while others' lives are impacted and destroyed. They deceive and impart fear without a second thought about what their actions could do to populations other than themselves. I wrote about this song 4 years ago, and I said this. I said the song is a blistering indictment of war profiteers and is an indictment of the military-industrial complex. It is as vibrant and angry today as it was when it was first recorded in 1963. And in case some are going to say, so, Michael, when was the last time Bob Dylan sang that song? I will tell you, I only learned this yesterday. I saw his last performance of the song, November 10th, 2010, Terminal 5, New York City. He has sung it 883 times. I'm not sure he's ever going to sing it again. But the really cool thing is, I am fairly sure that the first time I ever saw him perform, which was May of 1963, Gertie Spoke City, Greenwich Village, New York City, I am fairly sure he sang it then. Because the record is, he sang it at Gertie's 2 performances before. He didn't change his set list much. So I've sort of have the alpha and omega of the song. I think that's cool. Is that cool? Good. Yeah. In the context of this paper, I think this lyric has a double meaning. On one hand, in many parts of the world, those who run forensic facilities that violate human rights can comfortably hide behind walls with impunity. But on the other hand, those who are hidden behind these walls now optimally will have some tools that may bring public scrutiny to this forsaken part of society. In Masters of War, Dylan sang with hardness and anger, it's a very angry song, about the military-industrial complex in ways that were relentless and unforgiving. Oliver Traeger, who's a Dylan critic, writes of Dylan's focus on the reckless mongering ways of the war masters. There is unfortunately little, if any, relevant scholarly literature that treats the issues that I'm talking about today in the same way, relentlessly and unforgivingly. It's time for all of us to turn our attention to this problem and to take it seriously. Thank you.
Thank you so much.
Thank you.
This is, as I said, one of the things that we hope this association is for, is to not only talk about ways to do our practice and evaluation of our practice in a neutral and objective and scientific way, but also actually to advocate for our patients. And, you know, if in some ways, I think one of the messages that I take out of what you just said is that the forensic mental health patients have been sacrificed as a pawn by many different groups who've been interested in promoting rights for other kinds of patients. We've allowed forensic mental health patients to be ignored, and in fact, maybe to be the focus of our mistrust and fear of psychiatric patients generally. But that also means that we're being used as pawns, and we should not allow ourselves to be used that way, or our patients, right? So we should be promoting this.
Steve, I could not agree more. And of course, you're saying that is, obviously a hanging curveball to me to talk about the song "We're Only a Pawn in His Game," But it's the same thing. It's exactly the same thing. In fact, you look at the structure of that song, which is about the civil rights movement and the race relations in Mississippi in the 60s. I mean, there's some incredible parallels in what you just said. And you're absolutely right. We have basically, I say the global we, have kind of forsaken this population for all sorts of reasons, for empirical reasons, for normative reasons, and for sort of, utilitarian reasons and self-satisfactory reasons. And, the reason I chose this as my presentation topic today was I thought it was important, to talk about this so that people would sort of see how this is important and is an issue that has not gone away. I mean, my goodness, I could never give the same talk that I might have given back in the 1970s today about general issues involving community treatment, about civil facilities. But this one, it really hasn't changed that much, so that's what I wanted to do.